United States. So we've seen now in the last 80 years, 18 significant freedoms have been taken from us. And it's these 18 freedoms that I seek to restore. So let's go on from here and take a look at some of these freedoms and how to restore them. Now, I don't care how you answer these questions. Any way you answer the question of whether or not we have a police state in the United States, here in Ada County, Idaho, every one of these 18 attributes are present in our county, in our city, and in our state government. These are the 18 attributes of a police state that we didn't have in 1900. Now, for every cause, for every effect, rather, there has to be a cause. There's always a cause and effect relationship, whether you're talking about business or health or law or whatever the subject matter might be. If you're broke, there's a cause for it. If you're sick, there was a cause for that. And if you have a police state, there must have been something that caused it, because we weren't always a police state. You know it and I know it, that when we bring up this subject, it elicits a lot of emotional responses like, well, if you think it's so good in Poland, why don't you go to Poland? Or have you ever been to Poland? Or you don't know what you're talking about. And I know that these ultra-right-wingers and I guess ultra-leftists will tell you the same thing. Oh, why don't you go to Poland, you know? Responses like these fail to face the issue. Are we living in a police state or not? And I contend that these questions describe the attributes of a police state, and that most Americans are subjected to this kind of regimentation in the name of law and order. In Poland, we call this tyranny. Well, I don't know if they call it tyranny in Poland. I assume they call it law and order in Poland, and it's Dan Rather that calls it tyranny in Poland. And so we sit here and watch the 6 o'clock news, and Dan Rather tells us that what we're watching over there in Gdansk or Warsaw is tyranny. But it happens in the United States, and we call it law and order, or we call it radicals, and we call them hippies and other names, and dissidents. Well, I further contend that we cannot treat the disease until we diagnose the disease, recognize it, and begin to treat its cause. So if we're going to do anything about it, we better find out what's causing it, or we're never going to get to the root cause and then affect a solution to that problem. Well, I've never been to Poland, but the questions that I've asked here are all in force and effect here in Ada County, Idaho, and if they or any of these practices are not in use in Poland, it serves to prove my point in chief, and that is this. If we live in a free state, we shouldn't have any of these restrictions put upon our rights. And the fact that we do live under these restrictions to our rights shows how we have lived so close to the police state that we couldn't see it. Only the names have been changed. The restrictions are the same. We know there's a problem, but now what do we do about it? Well, there is one more fact to examine before the disclosure of the solution. From where do prisons and dungeons, or from where do prisons and dungeons as a form of punishments come? And the answer that everyone will agree to is that so far back in ancient times that who can tell? We'll all agree with that conclusion, that these prisons and dungeons are pretty old. We read in Joseph, or we read of Joseph, who was a biblical character back in Genesis, who was in a dungeon in Egypt in ancient times. Daniel, Peter, and all through the Bible, the pagan nations used prisons and dungeons to punish their criminals and political prisoners. The only exception is found in the time of Moses. When the Israelites crossed the Jordan River, they had a system of law. The common law is based upon substance and the land, as well as gold and silver. That gold and silver was the substance and is and was until 1933 in the United States. So the three requisites to the common law, as I've said before, are land, labor, and substance. And it was a crime to move a man's boundary marker. The common law and rights at law that our Constitution and Bill of Rights guarantee to each and every one of us is based upon substance at law. And the connection between the Ten Commandments, the Constitution, and substance at law is bound up in this axiom of law, that if there is a remedy at law, equity cannot prevail. So equity and the common law have to have boundaries, and they do have boundaries, and it's called a remedy. James Madison, the father of our Constitution, made reference to this when he said that the Constitution was tied to the principle that we assume every man will obey the Ten Commandments. Our common law came from England, but its roots are at Mount Sinai. Moses brought the law down from Mount Sinai, and it's recorded in Exodus 20. And the next 5 chapters of Exodus contain the criminal codes. And they're short and precise, and there are no prisons, dungeons, or political prisoners. The Israelites borrowed that system from the Romans, the Egyptians, and Babylonians, and they did so after the time of Samuel, about 1000 B.C. We have that system in America today, and I contend that it is unusual and cruel to lock a man up like an animal, and that we've borrowed, that is, the Israelites and these Christian nations of the Western world have borrowed that from the ancient Babylonians and the pagan nations around them. The act of punishing a victim for a crime by taxing him to house, food, and guard the wrongdoer is adding crime upon crime. When you punish the citizen and you punish the victim by extracting money and funds to house them in the king's dungeon, it is just adding a crime on top of a crime. And I propose to stop punishing the citizens of Ada County and stop the useless waste of the criminal's life and make him pay the cost of his wrongdoing. Let the criminal pay for that cost. Let's stop the profit in the law enforcement growth industry and use the productivity of the criminals in the law enforcement growth industry to make our lives more fruitful. So let's take a look at Joe's case again. Joe stole $350 cash, but he also threw the woman's purse away. So the victim, that is this woman, has suffered a further loss of time, pictures, credit cards, and all of the things that are in everyone's personal property or personal assets. So let's set a value upon the crime. It's a common law crime involving the loss of life, liberty, or property. The common law is designed to restore property and to remedy damages. If Joe's crime is valued at $50,000, which in this case I think is personally excessive, but for the sake of discussion and it's a starting point, let's use $50,000. We sentence Joe for 5 years or $50,000, whichever he prefers. However, because Joe is poor, which is the reason for his theft, we're probably not going to get the $50,000 out of Joe. So now we're going to enforce upon Joe the option of the prison, which no one likes because of the boredom, lack of purpose, humiliation. Or let's let him work it off. And here's how. As an example, in Idaho we have forests. The forests are like tinder boxes of dry leaves, limbs, dead trees, snags, and brush, which when ignited burns hot on the ground, burns up the trees, crowns, and kills the trees. If we were to take Joe out to Atlanta, Idaho, and put him to work in a productive capacity, it costs less than concrete buildings. Joe is not dangerous to anyone. Let's teach Joe the dignity of work and of making restitution to the victim and the cost of the crime. This convict labor is not a new idea. It's been used before and it's been abused when it was used. The 13th Amendment is not violated by the use of convict labor. I suspect that Joe and the many people like Joe will volunteer to go to Atlanta and do prison camp work on forest products, such as helping the forest fires or helping with forest fires, replanting of burns, cutting diseased trees, cutting firewood. And let's suppose that we paid Joe $5 an hour, or a piece rate. The more he produces, the more he makes, and the sooner he earns his freedom. Let's say Joe owes 10,000 hours at $5 an hour. If he works 10 hours a day, 6 days a week for 3 years, he earns his freedom. No parole or attached strings. Joe is a free man, and the victim receives her loss either in tax credits, cash, or direct payments from sales of the prison work. A program like this is not new. California has used a work program in the past. It's the unions and the law enforcement growth industry that will resist any change, not the prisoners. And I doubt seriously any citizens who are presented with the options of paying $50,000 of totally lost production, or of making the prisoner, or at least giving him an option of paying his way, would have any argument or any objection to such a program. It's these unions in the law enforcement growth industry that have stopped this practice in the 50 states, or at least in most of the states, and have been the prime objectors to such a program. But I contend, however, that they are losing more with the present system. No one's hurt by working on our forests, and there are other public projects that unions and other workers are not engaged in that need to be accomplished. I've interviewed numerous prisoners who have confided in me that they would welcome an opportunity to have a chance to work off their sentences. So let's look at an ancient example of common law damages paid for, which were paid, or the losses were paid when they were suffered. In Exodus 21:22, there's a quotation that says that if a man strive and hurt a woman with child, so that her fruit depart from her, and yet no mischief follow, it shall surely be punished, according as the woman's husband shall lay upon him, and he shall pay as the judges determine. So here's an example of damages for what we would call a crime today and would want to imprison this man. Here's an example of a common law damage. Again, in Exodus 27:7 is another example. If a man shall deliver unto his neighbor money or stuff to keep, and it be stolen out of the man's house, if the thief is found, let him pay double. Here's another example of letting the thief pay double. We don't have an example of letting the victim suffer loss of goods here and then be taxed to support the thief in prison, which constitutes punishment of the victim and is unjust and causes a greater loss than the thief. I mean, my goodness, our common sense ought to tell us that a guy that steals $350 isn't worth spending $50,000 on. I sure as hell don't want to spend $50,000 on a thief who steals $350. We wouldn't have done any more to him. We wouldn't have done much more to him if he'd have stole $50,000 or $500,000. What we're practicing with our prisons now is a greater punishment to the victim than to the criminal. Now, there are dozens of examples of the common law usage in Exodus 21 through 24. There's 4 or 5 chapters. There are too many examples to recount here for this TV show. If these scriptural examples are repulsive to you, then why don't we just leave God out of the equation? We never have listened to anything God had to tell us anyway. So let's ignore God and let's just rely upon our own self-interest and our own reason, logic, and common sense. We can see with Joe's example that it is the self-interest of all of us to change our prison system approach to crime and punishment. I don't presume to have every answer necessarily to every question, but I contend that this approach will reduce theft or make it profitable for the victim, one way or another. I'd a whole lot rather see Joe pay the $50,000 to the victim than to the law enforcement growth industry, which simply promotes more lawyers and more policemen and more jails. Well, let me give you another example of what happened to me. Some years ago, my car was stolen, and when it was recovered by the police, they gave me a ticket for leaving the key in the ignition. That's right. I left the key in my car, someone stole it, and they fined me $25. I contend that our system of justice is upside down when we attempt to punish the victim instead of the criminal. This is why most crimes are not reported to the police. The citizen knows that he'll not get his property back, and he may be hassled or punished by the police for his involvement as the victim. And you can all know and recount a number of instances, especially a very nationally prominent case where a citizen who was the next-door neighbor of a man shot and killed a burglar coming out of his neighbor's house, and who was tried and convicted and sentenced to prison for manslaughter. Now here's the victim being sent to prison. I don't know what happened to the burglar. All I know is that the guy that shot the burglar coming out of the house was sent to prison for manslaughter. Now that illustrates my point in chief. Now we come to the first issue in this brief, and that is the use of the police power of the state for the exclusive use of private insurance companies to protect their claims windows. The traffic courts have gone mad with power over the citizens in Ada County, using the judicial power here to tax by consent. And I'll concede that the practice is constitutional as it's being used because all of the victims, that is, all of the citizens, are volunteers into a driver's license contract or a quasi-contract by use of this driver's license. However, I contend that the police powers are being used indiscriminately against some free and natural citizens who are not subject to this Roman civil law. Now let me explain how the law merchant has crept in upon us and taken our inalienable rights from us and subjected us to this alien jurisdiction which is foreign to our Bill of Rights and yet accepted by nearly all of us as a part of some mysterious system that is in reality nothing more nor less than a police state tyranny. At some time in our history we had a constitution and we had law and order and freedom of action and a lifestyle something different from what we see in our society today, and I think all of you would agree that at some time in the past, something was different than what we have today. I'm going to use the traffic code to illustrate how we've enveloped ourselves in a Polish-style police state tyranny, and if it's not a Polish-style police state tyranny, then a South African style, or a Russian, or a Chinese style. Whatever it is, it's some style of foreign and alien jurisdiction and tyranny that's been imposed upon us that did not come from our Bill of Rights or from our Constitution. And we've done this in the name of law and order. Now in Idaho, Title 49, which is our traffic code, didn't exist at some time in the past. I mean, if I went back to 1889, you're going to have to concede that it didn't exist because this state didn't exist. So we begin with a time when there wasn't any traffic laws. And before there were any traffic laws, there was traffic or movement on the roads, the trails, or the highways. There was locomotion, friends. Whether people walked or pushed a cart like they did from Nauvoo, Missouri, or Illinois when the Mormons came out here, those people moved from Missouri and Illinois to Utah. And they didn't have driver's licenses, and they didn't have registered wagons and horses. Now, whether they came in wagons or on horseback, carriage or stagecoach, there was traffic. And in all of human endeavor, there are bound to be mishaps. And when our common law was in common use, the problem with fixing fault without any statutory law was difficult to fix because there was no law against speeding or stop signs or pedestrian crosswalks. So when a loss occurred, a long common law litigation would of necessity ensue just to fix the liability. Now, with the advent of the horseless carriage, that is the automobile at the turn of the century, we began to see the proliferation of traffic law and regulation. With the increase of regulation, we witnessed a move of the average person's status at law to privilege by contract in equity. The ages-old rivalry of the equity courts and the common law courts took a decided turn to equity by statute, and then the final demise of the common law by statute in Idaho, and in addition to that was H.J.R. 192, which took away substance at the common law in 1933. So at this juncture, on this driver's license issue, we've completed our book, and I'd like to invite you to send for it at Barrister's Inn. That's P.O. Box 9411 here in Boise, Idaho 83709. I'd like you to see that book, and I'd like you to go through it because many of those cases start with 1876 and 1889 and 1900 or 1904 or 1905. And they'll show you that at that time there were no driver's licenses and no registration. Well, now, 80 years later, we find the common law in use only in major crimes, and the grand jury is not even in use in Idaho. So we don't have the full function of our common law. If our Constitution is based upon the common law and the grand jury is a fixed right pursuant to the Bill of Rights, well then how can Idaho eliminate the grand jury? And if rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them, so says Miranda versus Arizona at 384 U.S. 491. How then can Idaho abrogate the entire common law by statute? And simply by getting everybody to waive the common law and their inalienable rights under the Constitution, and to volunteer into equity jurisdiction by contract. Now, we license everybody and induce them to accept corporate privilege for rights. And that, in a nutshell, is what's happened in America. No foreign power by force of arms or ideology has enslaved us. Our lack of understanding of our Constitution and common law heritage and the ignorance of, or our unwillingness, or our willingness rather, to obey the Ten Commandments has enslaved us to the civil law of admiralty and maritime law. That's an admiralty jurisdiction. I contend that if we were to obey the Ten Commandments of God, we wouldn't have this problem because, remember, as James Madison said, we're presuming that every man keeps the Ten Commandments. That's the presumption of innocence until you're proven guilty. But once you've given up the common law and you've gone into an equitable jurisdiction, then the question is, well, based upon the contract, if you haven't fulfilled the terms of the contract, we're going to presume you guilty unless you can prove that you have obeyed all of these terms and conditions of the contract. So do you see, you have a total renvoy between admiralty and equity and the common law. But how this came about is an interesting story. So let's go back in time to the turn of the century when our common law was in use, and let's visualize a scene. A wagon, which is loaded with mining supplies, traveling from Boise to Idaho City, is traveling northbound to Idaho City. A surrey, loaded with a family of 6, is traveling south from Idaho City to Boise. When approaching each other, the vehicles collide head-on, killing 3 horses and injuring 3 children in the surrey. The driver of the wagon is killed. The property damage is hundreds of dollars. Who then sues whom and for how much? Who was on the wrong side of the road? Was the driver of the wagon drunk? Was the driver of the surrey speeding? Who was negligent? Is there a third-party insurance company involved in this action? Well, at the common law, this case would be a very costly in terms of time and money to litigate, and both parties have rights, and the issues must be litigated in the courts, and a 12-man jury at the common law must decide the law as well as the facts of this case. Now, with the coming of the automobile, someone somewhere in the insurance business said, how can we cut costs and increase profits with the coming of this automobile? As more cars were put on the roads and the inevitable accidents and resulting losses that occupied the insurance industry out of the normal business necessity said, how can we cut costs and increase profits? I mean, that goes on in the boardrooms of every corporation in America. Now let's look at the problem of fixing fault in the Surrey wagon wreck on the road to Idaho City. Was anyone speeding? There's no speed law or statute. Was anyone drinking or drunk? Well, there's no law against drinking and driving your team of horses drunk. Who crossed the center line? Well, there's no law telling either driver which side of the road he should be driving on. Do the drivers have insurance? Well, there's no law or statute compelling a driver to have insurance. Were the drivers licensed? No, there's no licensing law. Now we begin to see the alleged need for traffic laws. But who is it that needs these traffic laws? The courts and the insurance companies need traffic laws. They need traffic laws for economic reasons. Whether the traveling public needs traffic laws for their health, safety, or protection is not, nor would it ever be, the prime motivating factor in the passing of traffic or any other law. Mercantile interests pass laws, friends. Proposed new law, statutes, and regulations come from mercantile interests. It's the insurance company. It's some government bureaucracy. It's some regulatory agency that wants new laws, statutes, and regulations, not those to be regulated. And those of us that are sitting here at our desks, when did you ever go to the legislature and lobby for the EPA? When did you ever go to the legislature and lobby for clean air or for OSHA or for anything? You know, ARCO is the biggest single contributor to the Sierra Club. Now, why would the oil industry want to support its avowed enemy? Because the Sierra Club is not an enemy of ARCO, it's an ally of ARCO. In 1900, every citizen went out to Oklahoma or Texas and bought a piece of ground and dug an oil well if he wanted to. Today in Alaska, There are 5 oil companies digging oil wells in Alaska, and not a single citizen is in Alaska digging oil wells, nor will there ever be unless we get our common law back. All that's designed to do when you lock up land is to create a monopoly for corporate business interests. And so the Congress has simply locked up the public lands of Alaska and then given it to those corporate interests that are able to get the special legislation needed and necessary to go drill for the oil. It's just that simple. It's the insurance company that goes to the legislature and gets the traffic laws passed. It's not the citizens. So for the sake of discussion, let's go into the boardroom of the Continental Casualty Company, hereinafter referred to as CCC, and let's listen as they discuss the Surrey wagon accident. The chairman of the board, we'll call him Horace Peabody, calls the meeting to order and announces, "Gentlemen, the purpose of today's meeting is to discuss ways to increase profits and cut costs. The chair will recognize Albert Throckmorton." Albert begins by suggesting that the company go all out to sell collision and public liability and property damage insurance to everyone who has a car, not just to business concerns. This will increase sales revenue, profits, and our competitive position within the industry. But how can we convince ordinary citizens to buy this kind of business insurance? Insurance is for business, not individuals. Well, Albert replies, "We just had a head-on accident between a wagon insured by CCC and an individual last year. After the case was settled, the court found the individual who was driving the Surrey guilty of negligence and he couldn't pay the damages. We'll use this scare tactic with newspaper ads showing the artist's conception of the wreck and the family farm being seized by the sheriff and the wife and kids crying as they have their home taken away from them. It'll be dynamite. A new growth industry will develop within the insurance industry. Ordinary people will be lining up to buy insurance on their cars. The year 1900 will go down in history as the year of the auto insurance policy. And we all know that these vehicle accidents are so rare that we'll hardly ever pay out a claim. Boys, I'll tell you, we'll be making a killing." Chairman Peabody takes a vote. Everyone is excited about the future of the auto insurance policy. Sales climb, agents abound, and the public buys insurance to protect them from the loss of their farms and their personal property. For only a small premium, we get all of this protection. So in 1910, what we need now are laws. In 1900, we needed the insurance policy. But by 1910, what we need now are new laws. So, in 1910, a meeting of the board of directors is called, and the new chairman of the board, we'll call him Andrew W. Warbucks. He begins by saying, "Gentlemen, I've called this meeting to order for us to discuss ways to cut costs and increase profits." Benjamin Jones rises to speak and declares to the board, "Our biggest problem, gentlemen, is with costs in our claims. Our losses to claims is staggering. This is especially true of accidents that occur at intersections. I think what we need is a stop sign law. And here's how this new stop sign law would work. We'd put up signs at busy intersections that say stop. If an accident occurs at this intersection, all we have to do to establish who is at fault is to look at who failed to stop at the stop sign. In this way, we can fix liability and save money in costly litigation. I propose that we send lobbyists to the state legislature for the new stop sign law, the new center line law, the new right-of-way law, the lane change law." Does that ring a bell? Do any of these laws ring a bell with any of you? Well, he goes on, "We should proceed cautiously in the name of health, safety, and welfare of the people. This will at first seem like regulation and regimentation, and it may elicit some reactionary hostility by certain constitutionalists who will claim that these laws violate their rights. However, these regulations are so slight that no one will mind the rules and they will not be enforced as law. The regulations will be evidence in court to establish fault when a loss occurs. Now, the beneficiary of this arrangement is the claims window of the insurance company. The board of directors will adopt the plan and work to sell it to the legislature and the people for the benefit of the people. No mention of loss of rights will be mentioned. The insurance company has a large financial interest to protect, so the money they spend is done to make more money. Since there is no financial interest in rights, there is seldom, if ever, any resistance to these new laws and regulations. So in the early days, these rules were not enforced as criminal statutes with pains and penalties because there was the common law protections and no evidence of loss, so no one lost rights to the act of failure to stop or for an improper lane change. When the loss occurred, there was no loss of rights because there was a loss, and the common law would use the statute as evidence to establish fault. So when the common law was working, the civil law was not. Now let's proceed on to 1920. The year is 1920. And what we need now are records on policyholders. So a meeting of the board of directors is called, and the new chairman of the board is Paul Warburglar. He begins by saying, I've called this meeting to discuss ways for us to cut costs and increase profits. So, board, our biggest problem is the repeated claims of some of our policyholders. They've numerous accidents. They've limited liability for their debts and insure themselves and drive carelessly. And as a result, they have accidents. I think that what we need is a record-keeping system among companies. This would give us the ability to refuse to insure unsafe drivers. We need statutory authority to accomplish these ends and a public relations program to sell this record-keeping program to the public. There may be some people who will complain about Fourth Amendment rights violations, but here again, no one would complain about this because rights have no financial interests and the insurance companies do. So the insurance companies can claim that the purpose of this new statute is to bring the people lower insurance rates. At this juncture, no one loses any rights because the new statutes only apply to insurance policyholders. And policyholders will agree by contract to give up their Fourth Amendment rights. 1930 comes along. And now we have a new need. The year 1930 comes along and we need licenses to create a privilege out of a right. A meeting of the board of directors is called, and the new chairman is John D. Rockefeller. So he begins by saying, Gentlemen, I've called this meeting to order to discuss ways for us to cut costs and increase profits. A board member who is a lawyer rises and says eloquently, I believe that driver's licenses should be in order and that a driver who is licensed to drive is the record keeping that we need. I see cases where people drive cars that shouldn't be on the road. After relating some cases, the lawyer points out that the public should be protected from incompetent practitioners of law. Some side benefits from this licensing law that are bound to spill over and protect the claims window are that we will have the power to revoke the licenses of the poor risk, just like a lawyer, and use the police powers of the state to do it. The state will keep our records for us on drivers and suspend driving privileges, keep poor risks off the road, and give us the means to identify these poor risks, and we'll charge them more for their premiums. We may even come up with an assigned risk program for these bad drivers. Another benefit is that all licensed drivers will be removed from their common law status and put under contract. They will no longer drive as a matter of right, but as a matter of privilege. This will expedite court proceedings. There will no longer be a need to try traffic cases at law. Traffic cases can be tried in summary proceedings, just like us lawyers are tried in summary proceedings when charged with misconduct in our practice. The board was ecstatic with the new licensing proposal. They quickly approved the plan and sent their lobbyists to the legislatures and promoted the new licensing laws to the people. The people loved it because they could show their new licenses to their friends and to other people who didn't have the new licenses, and they felt left out, and they felt inferior. People with a driver's license felt superior. It's like getting a new Cub Scout badge. Later, the issue of lost rights could be brought up by another generation. But for now, the licensing law was both popular and practical. Now, that takes us up to 1940. Gee, what do you think we need next? Well, I think we need stiffer penalties to enforce compliance, don't you? A meeting of the board of directors is called. The new chairman is Nelson Rocky Fuller, John Dee's son, and he calls the meeting to order, and he begins by saying that he has called this meeting to order in order that we might discuss ways to cut costs and raise profits. A board member rises and says that he thinks we need enforcement of our laws. It's time to stop this mollycoddling of criminals on our roads and highways. It's time we put the traffic offender on notice that we, the law-abiding citizens, will no longer tolerate the speeder, the illegal lane changer, the drunk driver. We need teeth in our laws. We need law and order. It's time to make it a crime to speed, to change lanes illegally or drive drunk. Now, gentlemen, as we all know, when a driver breaks one of the rules, he is statistically 3 times more likely to have an accident. And we know that our claims window is 3 times more vulnerable with these drivers breaking the driving rules. We need our policemen out on the streets writing tickets and enforcing our traffic laws in the same way that they would enforce any other law. This will be popular with the people. We'll tell them we're going to make the streets and highways safer for them. To sell the new law and order program, we'll need to show the people that, look at these accidents that are particularly gruesome, just like we do when we sell them an insurance policy in their living room. We'll support prosecutors running for office on platforms of law and order. And anyone who brings up rights that we don't support, and we'll brand them as being soft on crime. Soon, we'll have the people obeying traffic laws just like any other law. They will fear punishment and loss of property and will drive more carefully. This will cut our claims and increase our profits. Needless to say, the board was ecstatic. Now we get to 1950. What we need in 1950 is we need special traffic courts. A meeting of the board of directors is called. The new chairman of the board is Harold Stratison, and he calls the meeting to order. And he says, gentlemen, we need ways to cut costs and increase profits. An old-time board member, a lawyer, and an ex-prosecutor rises and begins by saying, I think that what we need is a streamlined court procedure for dealing with this enormous load of traffic crime. The courts are plugged up with the enormous load of cases. The people are angry with the slow process of their cases. When a man goes to court and is away from his job all day, it makes him angry. If he pleads not guilty, the costs get way out of hand. What's even worse is that there are too many cases being thrown out of court or dismissed without a judicial determination. This is especially true where a citation was issued in a case where an accident has occurred, and that adds to the later costs of litigation. What we need an equity proceeding in executive police court chancery to adjudicate these simple traffic cases. When executive summary proceedings are held, the time it takes for each case can be reduced to 60 seconds for guilty pleas to 90 seconds for not guilty pleas. And the trials need not be by jury in equity, but I think we should keep the jury process because it's good for public relations. But we should change the jury of 12 at common law to the jury of 6 in admiralty. This will be popular with the people, popular with the courts, and profitable both for the claims window of our company, but it'll also be profitable for the taxing districts, and the courts and the taxing districts will love it. Rights will not be an issue since there will not be any constitutional questions raised. Now that everyone has a driver's license, they all drive under privilege. Since everyone is under equity, there is no right by law. This proposal will speed up justice, create more revenue for courts and taxing districts, cut our costs at the claims window, and it will be popular with the people. The board of directors approved overwhelmingly. In 1960, the great need was, we need driver's education. A meeting of the board of directors is called. The new chairman of the board is John D. Doubletalk. He calls the meeting to order, and he says, "Gentlemen, I've called this meeting to order to discuss ways for us to cut costs and increase profits." A middle-aged man who was an ex-school teacher and educator rose and said, "The automobile is no longer just a novelty or a toy. It is a necessity. Our greatest losses to our claims window is now the young driver between the ages of 16 and 25 years of age. I propose a propaganda campaign aimed at putting driver's education as a mandatory subject into every high school in the country on an equal footing with math, English, and civics. Here is how the program will cut our costs and increase profits. In order for a young person to get a driver's license, he must enroll in the mandatory driver's education program. He must buy insurance and pass the course. We will educate this young mind to the need for insurance at the same time we sign him up for the equity jurisdiction. We will, in short, have the perfect equity subject in total admiralty jurisdiction. Within a generation in the traffic courts, no one will even bring up the subject of rights. We'll teach each and every student that to change lanes without signaling is a $40 fine. The subject of corpus delicti, or loss of life, liberty, and property at law, will be an anachronism. The new equity man will always react to the law in a positive way because he's taught to react to the law in a positive way. When he breaks a rule, he will always plead guilty because he has been taught to know the law and the rules. The citizen will always know when he is guilty, and he will no longer have to be concerned with archaic old common law rules like intent or corpus delicti and victim and loss and property or other complicated rules that could cloud the facts. When he fails to register his car and the officer gives him a ticket, he'll know immediately that he's guilty because the law tells him so. And the best way for us to increase profits and cut costs is to educate and create our own customers from their youth up." The board was wildly enthusiastic and adopted the educators' proposals. Well, by 1970, what we need is to ensure safer products. So a meeting of the board of directors was called, and the new chairman of the board is Ralph Nigger.